So just for the information, we will be starting in 18 minutes, 17, sorry, 17. So you have time for snack, for coffee, for whatever. Just to, do it in 17 minutes and then start the seminar. Okay, perfect. So we are starting in 3 minutes, so it's like the highest time for the last coffee, last snack, last I don't know what, but probably not the last wheel. It's not yet, not yet, not yet. So, oh, hello, Madalina, and yeah. So she's ahead of the whole
Hello,
situation.
Yara.
Hello.
Hello, everyone.
Okay. Możemy już tam włączyć na ekran? Okay. So that's Madalina, and Madalina, if you want to have a look into our classroom, so just in a moment you will see it, I think.
Good, because now I actually see myself double, and it's a bit weird. It's a bit avatar-like.
Okay. So just a moment. And now, I hope you can see us.
Perfect. Hi,
Yeah.
hello, everyone. Good afternoon.
And we are, live on 4K, so it's really something. Okay, so we are
It's
having...
amazing, and I'm actually quite sorry that I'm not there with you, because I think the discussion always in presence is sometimes a bit more interesting and engaging.
Exactly. So we will be starting in 1 minute. So Madalina, the floor will be yours in 16 seconds. So 60 seconds. So just a moment. Okay, so yeah, I think it's the highest time to start. And Madalina, if you would be so kind and just let this beautiful man on my right say a few words, because we have great pleasure just to have here the legend of Polish judiciary, and now the Deputy Minister of Justice, Mr. Dariusz Mazur from Kraków. So just a few words from the Minister of Justice. Deputy. So far deputy, but you never know in politics. So Dariusz, the floor is yours.
Thank you very much for giving me the floor. It's a great privilege to open this meeting, this conference. Just a few minutes ago, I was at the meeting in the Ministry of Justice, where we created the codification committee, which is going to build a new system of ordinary courts and also the new system of the public prosecution office. So the story of the Polish system of administration of justice and the system of public prosecution office within the recent few years, as you probably more or less know, is quite a bit complicated. We faced a great attack against the independence of the judiciary, but it was preceded by the attack against the independence of the public prosecution office. In fact, we don't have well-grounded traditions of the independent public prosecution office. In the communist times, the public prosecution office was very deeply dependent. Later, after regaining full independence, for quite some years still we have joint position of the Minister of Justice and General Prosecutor Public. Why? Because the independence of the Public Prosecution Office is not guaranteed under the Polish constitution. Fortunately, in the years 2010, between 2010 and 2016, there was such an episode during which these positions were divided. For 6 years, it was one term of office of the General Prosecutor Public, who was not the Minister of Justice at the same time. It was a judge, which was probably not the great idea to appoint a judge for this position, because he didn't have anything to do with public prosecution office before, so probably we could have imagined much better candidate for the position, in spite of the fact that the man as a judge was quite solid, but not as a general prosecutor public. And for recent 8 years, or let's be precise, from April 2016, positions of Minister of Justice and General Prosecutor Public were reunited. What is more, the former Minister of Justice and the General Prosecutor Public, in the moment of joining of these positions, has been reinforced with very strong prosecutorial powers. He could influence any pending preparatory proceedings in very direct way by giving binding commands regarding particular procedural steps, by assigning a case to a different prosecutor if he was not glad with what was going on with the case, or with revealing to the press at any moment of any information regarding pending prosecution, pending case, which was used as a kind of baton against the opposition. So this informations, which should be classified in normal conditions, were quite often officially or unofficially delivered to the right-wing press in order to exert a kind of pressure or stuff like that. The effect of these activities was quite obvious. So some people who should face prosecution, especially from among the members of the ruling camp, didn't face this prosecution. On the other hand, some pending cases which should be continued against the members of ruling camp has been discontinued. And now we are at the turning point. We are going to come back to the situation in which the position of the General Prosecutor Public and Minister of Justice will be divided. There is almost ready draft law in this respect. So the future General Prosecutor Public is going to be public prosecutor with 20 years, at least 20 years of professional experience, including 10 years as a public prosecutor. And I strongly believe that in the future his purely prosecutorial powers will be quite limited comparing to what was happening during recent years since 2016. I will finish my short introduction with quotation from Łukasz Piebiak. This is a man who is a judge. However, it is still, yes, it is hard to believe. He used to be a deputy minister of justice who was responsible for the phenomenon which was called troll farm in the Ministry of Justice. It was a smear campaign against judges orchestrated in the former Ministry of Justice, and he once commented, sitting as the Deputy Minister of Justice, he said more or less like that, well, it was quite easy to reform the public prosecution office because it was not constitutionally protected. It was much more difficult to reform the judiciary because of this awful constitution. And that's our reality not long time ago. But I strongly believe that it will change soon, so we are on the right path to do that. And I think in this context, the place of this conference is very proper, and the timing of this conference is proper as well. Thank you very much.
Thank you very much, Minister Mazur. Well, that was the great pleasure. And I think now it's time for our leader of the consortium and the leader of the leaders of the partners, so Madalina Moraru from EUI from Florence. Madalina, now the floor is yours.
Thank you, Jarasz, and good afternoon, everyone. I would also like to congratulate Darius for the new position. This is a good news. We had the pleasure to hear Darius in a previous intervention, actually in the first cross-border event organized within Trial, which is the framework that is hosting also this event. And it was an enlightening presentation. So I hope we will stay in touch and from now on to hear more good news on enhancements of judicial independence in Poland. So with that being said, let me introduce myself briefly, and also the Trial project that I've mentioned is hosting also this event today. I have a double hat, so I'm an associate professor at the University of Bologna on EU law, but I am also an assistant professor at the Center for Judicial Cooperation of the European University Institute. You see the logo here. And here at the Center for Judicial Cooperation, together with Professor Gabor Halmai, we are coordinating the Trial project. So in a few seconds, I will share my screen with the PPT slides, some few information on the project, but I don't think I am, I just see a message, Jarasz, that I am disabled to sharing my screen. I don't know if something could be done against that.
Not now.
Unfortunately, I cannot, I don't have the right to share anything on my screen. So I don't know if something can be done. It says that host disable participant screen sharing. Okay, so.
You are the host now, Madalina, so it should
good
work.
Thank you. So in a few seconds, this is the project Trial is entitled, in its long title is Trust, Independence, Impartiality, Accountability of Legal Professions, but also Freedom of Expression. And what we are particularly looking into this project is to explain and disseminate knowledge on how EU law, and in particular also the Charter, can ensure and improve standards on independence, impartiality, accountability, freedom of expression, so the leading pillars of rule of law. It is a project that is aimed not only as prosecutors or judges, but all legal practitioners, so including lawyers and jurists. And it brings together 11 members. 9 of them are academics, so universities, and the other 2 are representing different legal professions. We have the Italian School of Magistracy and the National Association of Romanian Bars. This is the 4th workshop that is organized within the framework of Trial, but there are other 8 cross-border training events, all tackling different themes related to rule of law. And they will continue not as is written here, December 2024, but actually we have extended the period until end of February 2025. So for those interested on rule of law topics, there will be plenty of other opportunities to participate. The framework of future cross-border events is similar to this one in the sense that we encourage both in-person participation, but also online for those that cannot attend in person. For each of the events, there will be a booklet trying to summarize not only relevant European jurisprudence, so judgments issued by the European Court of Human Rights or the Court of Justice of the EU, but also leading judgments from at least 8 national jurisdictions. I think this is something the more interesting aspect because while we have public free access to jurisprudence of the Court of Justice and European Court of Human Rights, and they're translated and available in English and French. For other national judgments, they, of course, legitimately speaking, issued, delivered in the national language. And although they might raise new solutions to how we can tackle rule of law problems, we cannot access to them because we might not read the local language. So one of our objectives is to disseminate these national judgments that could be of use to legal practitioners from other member states. We have collected already quite numerous judgments. More than 100 national judgments are available in the Center for Judicial Cooperation database. The link you can see on the webpage, but I'm sure that Yara's doing the sessions on hypothetical case studies would also refer to this platform. In short, the key questions that we want to address in the project is how various judicial interaction techniques contribute enhancing rule of law requirements at the national level. By judicial interaction techniques, we refer to consistent interpretation of national law with EU law, the use of the preliminary reference procedure, the application of national law on the basis of the European Convention of Human Rights, of EU law, the use of mutual trust, which of course in the area of freedom, security, and justice, both criminal cooperation and asylum, as well as civil cooperation, is essential, as well as the use of principle of proportionality between fundamental rights and other public interests. And secondly, to identify and address the challenges in using these judicial interaction techniques to address the rule of law issues. And so far, Poland has been the origin of most of the judgments from the Court of Justice, showing how sometimes it's difficult for an ordinary judge to resort to preliminary reference procedure because of the opposition from higher court. But as you will see in the project, is the database and the training materials that we're developing. It's not only about jurisprudence originating from Poland. There have been issues on freedom of expression, judicial organization also originating in other countries, including Western Europe, such as Italy, Spain. And of course, the freedom of expression is a continuous issue in Portugal. The project will, when we started actually the project, this is a continuation of another 2 years project that we have finished last year. The topic of rule of law was quite limited in terms of the intervention of the Court of Justice, and legitimately speaking, because judicial organization, national judicial organization, falls within the competences, exclusive competences of the member state. Nevertheless, through different interpretation and the use of Article 19.2, the Court of Justice has increasingly set standard on almost all major aspects of national judicial organization, from the composition of judicial councils to judicial appointments, judicial liability regimes, power of apex courts to limit European judicial dialogue, judicial salaries, the independence of public prosecutors, case management, freedom of expression of judges and defamation of judges, which is indeed a topic where the Court of Justice has not been the key actor in setting the standard, whereas we find most of the guidelines in the jurisprudence of the European Court of Human Rights. So just an example to make you interested of the work that we're carrying out in the project, and that you will see in the booklets that we have developed. So far, there have been 3 events, cross-border events, that have been organized, each with its own booklet. And I have to mention that they will be publicly available on the e-learning repository of the project. Each of you will receive access to it via password, so your own individual credentials, so that you can access this material long after the end of this event. So I've mentioned that the focus of the project is on judicial interaction techniques, so meaning how courts, through dialogue between themselves, can solve an issue related to rule of law. And here on the PPT slide, there's only one example originating from Slovenia, addressing a question that might sound quite national, so not necessarily related to EU law. For instance, can members of the disciplinary court also be members of the Judicial Council? And by rephrasing this question in terms of a right to access to an impartial tribunal, the Slovenian Supreme Court has brought in the implication of Article 6 of the European Convention of Human Rights, but also relevant jurisprudence from the Court of Justice. All this for the purpose of interpreting a provision in the Constitution. The end result was, of course, that members might appear quite logical, that members of disciplinary court cannot also be members of Judicial Council, especially when they have to deal and decide on disciplinary proceedings. But this was done, like I've mentioned, with the help of judicial interaction technique. So I will finish here, but I encourage you to have a look, if you're interested on the topic, first at the database, but also at the future list of cross-border events. And once again, I wish you a fruitful discussion during today and tomorrow, and thank Jaras for putting together such an interesting and rich program. Thank you very much for your attention.
Thank you very much, Madalina. I hope you will stay with us for a moment, because the minister is leaving now. Yeah, he's quite busy, and especially in these turbulent times that we are having now in Poland. Bye-bye. So, okay, so that's the time to say goodbye to the Minister of Justice. And yeah, so as you could see, the agenda is not very packed as it is usually on such a seminars, that you are having 17 speakers or 19 moderators. So I was just thinking about, well, of course, about the quality as always, but not with this overwhelming quantity that we will have. So now just let me briefly guide you through the program that we were preparing for months even. So today we will start with the members of the, well, we have the members of the Lex Super Omnia. So we are having the Association of the Prosecutors, of independent prosecutors from Poland. And so just again, let me start with a very short riddle. So is there anyone who remembers what happened on 3rd of December 2021? 3rd of December 2021. And the 4th of December also. That's a tip. Well, we had a seminar. We had a seminar of the trial 1. So of the first of the previous project. And that was the seminar that when I was asking the prosecutors will it be possible that I will make some pictures and post it on our social media social media account of INPRIS, so of our think tank? They were quite reluctant, let's call it this way. So yeah, the times changed a lot. So now we can also have the minister, the deputy minister. Now we are having also some very prominent prosecutors here at the place. Not to point anyone with my finger. But anyway, so yeah, it changes. And it also, I think, gives hope to our friends from Hungary. You just need always to have hope and not to lose your hope, because times they are really changing. So first, we had the introduction done by Minister Mazur. We have the introduction done by Madalina. In our program, there were also some possible interventions from the members of MEDEL. Well, also the Lex Super Omnia is the member of MEDEL, am I right? Yeah, so we already have the people from MEDEL here, but Monika Frąckowiak, Vice President of MEDEL Association, she wrote just a very short welcome message for us. So she wrote, "I wish I could take part in such an important seminar. As a MEDEL vice president, I know how important is not only the freedom of expression and association for every European citizen, but especially for us, lawyers. I know that Polish prosecutors will take part in the seminar. I am full of respect to their efforts during the constitutional breakdown in Poland. I'm looking forward to seeing you on another day." So these are some words from Monika Frąckowiak, the vice president from MEDEL. Okay, so before I will give the floor to Prosecutor Paweł Pik, I will just guide you through the agenda for today's evening and tomorrow. So we will start with the introduction to the Association of Prosecutors, but also to the challenges the association was facing, but also to the challenges that the whole prosecutorial office was facing in this, let's say, dark times that we overcome. Let's hope we overcome this. Then Izabela Delia Popa, lawyer from Romania, she will present the Kövesi case, because the Kövesi case is the case of reference for the prosecutorial freedom of speech, maybe also about the freedom of association. Then we will have Mohor Fajdiga, and Mohor is an amazing person also from Slovenia. He's the member of the trial consortium. And Mohor was the person responsible for the previous seminar, the seminar in Ljubljana, about the freedom of expression of judges and freedom of expression and association of judges. So as you can see from the title of his presentation, so he will try to compare, because probably the sentence like mutatis mutandis will be the most frequently used sentence during our seminar, because we don't have such a rich jurisprudence about prosecutors, but we are having quite a rich jurisprudence about judges. And also this empty chair belonging so far to our Deputy Minister of Justice, Judge Mazur, he is always having his case in front of the disciplinary court. It's very, very strange, because he was in one of the press interviews, he was accusing the head of the Constitutional Tribunal and the president of Supreme Court. So I'm personally very curious what will happen in his disciplinary case, whether it will be discontinued maybe, or whether there will be any pressures from the Ministry of Justice, but I'm only kidding. So, and then we will have the coffee break. And then Łukasz Bojarski, who just defended the PhD thesis at the University of Oslo about judicial resistance. So he will try to guide us through the meaning and his interpretation of the judicial resistance, but also asking the question, is it possible to have the prosecutorial or just the legal resistance? And also he will mention the legal complex and all his findings that he did during his research. So, and then we will finish, I hope, on time, just 7:15, and then we will have dinner, and also, for those who are joining us online, you can also have a dinner. You're allowed to have dinner. But maybe it's too early to have dinner at 8 o'clock, especially in Italy or in Spain. Okay, and tomorrow, we will start with a lecture from Jakub Jaraczewski, and he did his research, his homework, again, about the freedom of expression and association, and I strongly encourage you to take part in his lecture, because he will also compare some American standards, but also some findings about, well, I heard that he will speak also about the prosecutorial membership in the association of the people that are catching fishes. I just forgot the name, but the Fishermen's Association. So is the prosecutor allowed to be the member of the Fishermen Association? And then we will have a coffee break, and then Karolina Kremens, she's a professor from the university in Wrocław, and she's a former prosecutor also. So she will speak about the independence of the prosecutors, whether the prosecutors are independent or they aren't in EU member states. And I hope we will also have Catharine van de Heining from the University of Antwerp. She also the prosecutor, to discuss what Karolina will say. And then we will be working on 2 hypotheticals, prepared especially for those workshops, so essential hypotheticals about prosecutors, based on European experience. And then we will have lunch, and then we will finish with the discussion, with some findings, with also questions and answers. I hope Karolina and Kuba will be with us also, just to show, because Kuba represents also the NGO, while Karolina, she's the member of academia. So we will again have like this dialogue with the academia, but also with the NGOs. So that's more or less the plan for upcoming hours. And now, without further ado, just with 15 minutes of delay, so that's really nothing. So I give the floor to prosecutor Paweł Pik, then Isabella from Romania, and then Mohor straight from Ljubljana. Are you, Mohor? Okay, perfect. So you just need to remember that Slovenia is not having amazing bikers like Mohoric, and not only ski jumpers, better than the Polish one, but also the great scientists and the great academics. Okay, Prosecutor Pik, the floor is yours.
And talking about Slovenia, also great wines. Hello. Okay. Yeah. Okay, so welcome everyone. It's a pleasure to be here. Thank you very much, Jarek, for the floor. Thank you very much for inviting me here. Let me shortly introduce myself. I'm a prosecutor from Gdańsk, and currently I'm a chief prosecutor of the Divisional Public Prosecution Service in Gdańsk since February. And the presence of my colleague, Dariusz Mazur, the Minister Dariusz Mazur, has reminds me on all the good times when we had that constitutional crisis, and Darek and I were like co-speakers on such a meetings quite often here in Poland and also abroad. And to be honest, that was really a good time, although the situation in Poland wasn't that good. I will try to be brief, but let me just tell you a little bit about the situation of the public prosecution service in Poland in constitutional crisis, and then I would like to very shortly say something about our association as a member of the Polish Association of Prosecutors, Lex Super Omnia, and a member of the board. I would like to explain you our main goals and our actions as Association of the Prosecutors. And at the end, I would like to say just some words about the future. So what are the plans of our association and the prosecutors for how do we see the future public prosecution service, and the position of the prosecutor in Poland and in Polish maybe constitution, as we hope. First, just after the party, Law and Justice, so the populist party, had taken the power in 2015, they started to work on the new act on public prosecution service, and the act was introduced in January 2016 and went into power in on 4th March 2016, together with the regulations enacting it. And based on that act and those regulations, 24 prosecutors were demoted. The high-rank prosecutors, high-experienced prosecutors were demoted without any explanation, without anything, to the lower positions. And some of those prosecutors are present here. So maybe later they will just tell you a little bit about the situation, their particular situation. But that happened really very quickly, and nobody had been explained in any way why he or she were demoted from their rank to the lowest rank in public prosecution service. More than that, more than 300 prosecutors were made a difficult decision to retire. Some of them were forced to make that decision, and as you can see, the situation of the public prosecution service just at the beginning of 2016 was really critical, as a couple hundred of really the most experienced prosecutors were demoted. It was just the beginning. As the new national prosecutor had said that the prosecution service should be ruled by the rule of the stick and carrot. What does it mean? As Minister Dariusz Mazur had said, the new act on public prosecution service joined the position of the politician, so the Minister of Justice, and the Prosecutor General, so the head of the public prosecution service. It was the beginning of politicized the public prosecution service, and the stick and carrot rule was simply to give the benefits to the prosecutors who are loyal to their political superiors, and on the other hand, it also meant the official and unofficial persecutions to those who would like to respect the rule of law and who dare to speak their minds and openly criticize the situation in the public prosecution service. So the stick on one hand and the carrot on the other hand. And that is what really happened. How independent prosecutors were persecuted. First of all, the disciplinary proceedings and the criminal proceedings were opened against those prosecutors. Again, some of them are present here in the room. And also the civil lawsuits against the prosecutors who dare to criticize the management of the public prosecution service. Also the limitation in teaching or academic career, as the superiors of the prosecutors in Poland are allowed to object the activity with outside the service of outside the service as teaching or doing the academic career. And I think the most important and the most binding were the secondments of the prosecutors in the middle of the COVID crisis, of COVID epidemic, a couple of 100 kilometers from home. And it was, the prosecutors were informed at the end of the week, like on Friday, to be present a couple of hundreds of kilometers from home, usually in a very small towns. You can imagine that it was in the middle of the epidemic, so no public transport, no hotels, nothing. And people were supposed to be present in a couple of days, couple of 100 kilometers from home. And it happened to a couple of members of our association, but also to the prosecutors who were not members of our association. The secondments was quite often, not only to the members of the prosecutors of our associations, but also to the prosecutor who just tried to obey the rule of law or to criticize the situation in public prosecution service. Sometimes it happened, it meant only the demotion to the lower level of public prosecution service within the city they lived, but very often quite a lot from quite a long distance from home. What was the purpose for that? Actually, it was to create 100% politically dependent public prosecution service. And it was also the politicians succeeded. What they had done was actually, on one hand, to stop the investigation that were opened against the politicians or the people associated with the politicians of ruling party. On the other hand, to conduct the prosecution against the opposition, in general people who are opposite the ruling party and the management of the public prosecution service. And the result was very, very satisfying for the politicians. So that we had the cases that were prosecuted very, very long without any final result, without any indictment, without anything. And on the other hand, all the investigations that there should be open against the prominent politicians, prominent members of the party or their associated people, were actually very quickly discontinued. What is also important, that the management of the public prosecution service were not that much interested in the rest of the cases. So they were only interested in those political cases. So the result in 2023 was that here in Poland we had the most expensive public prosecution service in the whole European Union. So so as prosecutors, we are the richest country in European Union. So we do have the about 6,600 prosecutors, which is the biggest number in the whole European Union. And the budget of the public prosecution service increased by almost 40% at that time. The result, on the other hand, the results on our work are the increase of the cases by not 60, not 40, not 70, from 375% to almost 800%, by increase of the arrests, also by hundreds of percent, and the length of the investigation went up also by hundreds of percent. So that was the result of the actions taken by the management of the public prosecution service. It all had ended in, luckily, in October 2023, and now we are trying to rebuild the, or to, maybe it's better to say, to build the new public prosecution service in Poland. But first, I would like just to say some words about the, our association. So it was a kind of reaction to the degradation of the independence of the prosecutors. In 2017, we registered the Prosecutors Association Lex Super Omnia, and the first president of our association was Mr. Krzysztof Parchimowicz, and since 2021 our president was Ms. Katarzyna Kwiatkowska, who is over there. Our first and main object was to make a public prosecution service in Poland a part of the judiciary, so move the public prosecution service from the position of the highest investigator, highest police officer, to the part of the judiciary, and to make the public prosecution service a constitutional body, so to be present in the Polish constitution. As currently in our constitution, and the public prosecution service is mentioned only once, and it's the constitution says that the member of the parliament cannot be a prosecutor. So we are not in the constitution, and that's why the guarantees of our independence are very weak. And also it was the first goal, first aim of our association to make the public prosecution service a constitutional body. We also our mission is also to ensure the democratic principles and rule of law, that they are respected, and the prosecutors are independent and autonomous in the decision they make. And we also criticize all acts of the violation of the independence of the prosecutors as well. For those actions, we experienced quite a lot of persecutions, as I mentioned before, but those were the most important ones. But also we were not given some awards, some financial awards, which were given actually to all the prosecutors, for example. And but actually, right now we are the biggest association of prosecutors in Poland, although we do have only about 6% of our members are only 6% of all the prosecutors in Poland. This is the result of, I think, that the public prosecution service in Poland was and still is based on the pro-Soviet system, and unfortunately the hierarchical subordination in public prosecution service is still very important, and it's very deep in the mind of the prosecutors. And it's totally different when we speak about judges, because since the communist breakdown in 1989, the ethos of the independence of the judges were very, very strong in Poland, and actually here this is the reason why the judges could much stronger resist against the constitutional crisis and all the actions against the independence of the judges. As you can see, it's very easy to destroy something, but it's really difficult to rebuild it. As an association, we decided to introduce a draft law on the public prosecution service, a new one. There's nothing, not even a single element from the previous acts of law. And we started to look beyond the river of Oder, which is our western border. So we started to take some experience from Western countries, and we wanted to make a prosecutor as a part of the judicial and an independent lawyer. It's not very easy, to be honest, as prosecutors are always in the European Union a little bit aside of the judiciary. As Jarek mentioned, there are not too many jurisprudence on the public prosecution service. Although we are lucky because of the European arrest warrant, and it was the reason why the European courts, to be honest, started to notice the public prosecution service. It all started from the famous Lübeck and Zwickau case, when the Court of Justice explained that the public prosecutor may be a part of the judiciary, but only when he or she is independent from the executive. And it all started from the case, but there are many other jurisprudence concerning the prosecutor as a part of judiciary and the conditions on which a prosecutor can be, as an independent body, can be considered as a part of judiciary. And this is what we really want to achieve by our draft law. And just to sum up, I would like to say that there are very interesting opinions issued by the consultative committee of public prosecutors. It's a body of Council of Europe, and in those, the last opinion, number 13, the committee mentioned quite important things, that the public prosecutor in a democratic country is like the watchdog of the independence of the courts. And we should take all the possible means as a prosecutors to guarantee the independence of the court. And our second task is to protect the human rights. And this is how the independence of the prosecutors can be defined. On one hand, as a watchdog of independence of the judiciary of the courts, on the other hand, as a guarantor of the human rights. Thank you very much.
Thank you very much, Pavel. And it's really amazing. You just reminded me that there are some prosecutors exactly here in this room that were seconded somewhere in the middle of pandemics. And yeah, just speaking about independence, that's the big question mark, whether the prosecutors can or are independent. Okay, so now it's time for Isabela de la Popa. Isabela is also amazing person from Romania, and just it was absolutely short notice when I proposed her just to share her thoughts about Kovesi case. So speaking about jurisprudence, speaking about the references that we are having in the European law, in the European jurisprudence, I think it's the highest time for Isabella Della Popa just to present her thoughts on Kovesi case. Isabella, the floor is yours. I have your slides and I will change the slides using the clicker, just the magic clicker. I think it will go like this.
Thank you so much, Yaras, for your kind introduction. I got really touched and a bit nervous right now. I hope I'll manage.
Don't be, the prosecutors are also human beings, so yeah, just, I can confirm.
It's an honor to meet you all, and it's an honor to meet Mr. Pavel Pik, which I truly thank for his insight in the Polish system and the very clear presentation. For me, it was very clear, although I'm Romanian and I had no knowledge on the Polish judicial system. We don't have a similar statistic of prosecutors joining associations as the one in Poland. I understand from Mr. Pik that it's 6% of prosecutors that are organized or reached associations. But I do believe, and that's my personal opinion, that the percentage is quite similar in Romania. Today, I will briefly present the Kovesi case and the Kovesi judgment of the European Court of Human Rights. I have prepared some slides, not knowing if Yaras would allow me to present them. Yaras, if more simple to you, I can share my screen. I don't know if you would allow me to become the host for my very short presentation. Okay, that should work.
We already have your slides, so just let me know. And by saying next slide, I will work as a clicker also.
Thank you so much. So my name is Isabella Della Popa. I am a lawyer in the Bucharest Bar of Romania, and I participate to Trial 2 project as member of the National Association of the Romanian Bars. I've been also in Trial 1, and it's a great pleasure to also take part in Trial 2 project. I would start my presentation with a brief introduction on the applicant. This is not a customary presentation because I've chosen to treat the subject matter in a different way than the ordinary. Maybe, or most likely, the great majority of the persons attending the seminar do know who Laura Codruța Kövesi is. If we can move to the next slide, please. Laura Codruța Kövesi, I've also put a photo of her there. She was the Romania's youngest and first woman prosecutor general, and she had served as head of the Romanian National Anti-Corruption Directorate for 5 years. She was supposed to serve for 6 years, but as a spoiler, her mandate was prematurely terminated by the Minister of Justice upon his initiative. Now, at present, Laura Codruța Kövesi serves as the EU's first anti-fraud prosecutor in charge of the new European Public Prosecutor's Office, EPPO, and she's basically in charge. She's the head of the department handling anti-corruption cases at EU level. Well, what was her wrongdoing, or the alleged wrongdoing? If we can go on to the next slides, please. Yaras. She was accused of a wrongdoing, which the European Court confirmed it was not. And if we can continue, please. Well, she was serving as the head of the Romanian National Anti-Corruption Directorate. She has publicly expressed her views, her professional opinion, by means of various interviews and public statements. And she expressed her criticisms on the legislative reforms affecting the judiciary in Romania, also on issues related to the functioning and reform of the judicial system. And not at last, she expressed her views and concerns and also criticisms on the competence of prosecutors to investigate corruption offenses, given the current legislation in force at that moment in time. Well, she was appointed as head of the National Romanian Anti-Corruption Directorate in 2016. The appointment of the chief prosecutor is generally made in Romania, is made by the Romanian president of the country, based on two prerequisites. And if we can go to the next slide, please. So the president of Romania can appoint or remove a chief prosecutor from his or her position based on the proposal of appointment or removal of the Minister of Justice, and secondly, based on the endorsement of the Superior Council of the Judiciary. So Laura Codruța Kövesi occupied the position based on a first mandate from 2013 to 2016, and then the Romanian president reappointed her for a second mandate from 2016 to 2019. Given the fact that she expressed publicly her opinions, views, and criticisms on the envisaged judicial reforms in Romania, the Minister of Justice, which is a political person in Romania, evaluated her and the institution she was running at that time, and draw up a report on the managerial activity of the National Anti-Corruption Directorate. The report was really hard on the institution and also comprised the proposal to remove Laura Codruța Kövesi from the head position she was occupying at that point in time. The report was sent to the Superior Council of the Judiciary to obtain the endorsement, which the Minister of Justice considered at that point in time that it was just a formal procedure. Surprisingly or not, the Superior Council of the Judiciary, by a majority of votes, decided not to endorse the removal proposal, which was made by the Minister of Justice. In this context, the President of Romania refused to sign off on the proposal to remove her from the office. I need to make some clarifications on the facts, and I would ask Yaras, please, to move on to the next slide. In the report I was talking to you about, the Minister of Justice, whom you have him on the slide, held that the views and opinions that Laura Codruța Kövesi expressed in her professional capacity, and I quote, mutilated the image of Romania. That was what the Minister of Justice claimed against the chief prosecutor. As a very side note, the Minister of Justice, whom you have on the slide, was also my criminal teacher during law school. I know him quite well. Of course, all these decisions had a very strong political background. Well, in response to all these facts, the Prime Minister of Romania lodged with the Constitutional Court of Romania an application to resolve various constitutional conflicts. If we can move to the next slide, please. So the Prime Minister of Romania at that time, who, allow me to mention, was not a friend of the president of the country, claimed that there were two main constitutional conflicts, one between the Minister of Justice and the president, and a second conflict between the government and the president. And these two main constitutional conflicts derived or were caused by the refusal of the president of the country to follow up and sign the removal proposal of Laura Codruța-Kövesi from her position of chief prosecutor. The Romanian Constitutional Court, by its decision 358 from 2018, forced the Romanian president to dismiss Laura Codruța-Kövesi from the position of chief prosecutor of the Romanian National Anti-Corruption Directorate. In this context, Laura Codruța-Kövesi addressed to the European Court of Human Rights, claiming violation of two fundamental rights, the right to a fair trial provided by Article 6 and the right to freedom of expression provided by Article 10. As the outcome of the facts, as I was saying, the Constitutional Court forced the President of Romania to sign the removal from the office of Laura Codruța-Kövesi on 9 July 2018. She was removed, although she was supposed to end her mandate 1 year later in 2019. By the decision of the European Court of Human Rights, dated 5 May 2020, the court unanimously held that there had been a violation of both Article 6 and Article 10. The legal issues in brief that were analyzed by the court were the following. So the court analyzed first whether the views and criticisms expressed by the chief prosecutor in her professional capacity, so not as a personal opinion, but in her professional capacity, fell within the context of a debate on matters of great public interest, which entailed and called for a high degree of protection for her freedom of expression, and also implied a narrow margin of appreciation to be afforded to the authorities of the respondent state. Also, the court was called to analyze whether the interference of the Romanian state authorities, the interference being the removal from the high-rank position of the chief prosecutor, motivated, of course, by her views and opinions expressed, was a consequence of the previous exercise of her right to freedom of expression. If we can move on to slides, please. Yeah, the next one, please. The judgment of the European Court of Human Rights is a conspicuous one, if I can say so, because for the first time in Romania's history, the court held that by means of a decision of the Romanian Constitutional Court, which forced the President of the Republic to dismiss the chief prosecutor from her position, there has been a violation of the independence of the judiciary and of the freedom of expression of prosecutors. The reasoning of the court is amazing. From my point of view as lawyer, and I do believe that from anyone's point of view, the court noted that the premature termination of the mandate constituted an interference with her right to freedom of expression. The court noted that no evidence were brought to show that the measure had served the aim of protecting the rule of law or any other legitimate aim. And also the European Court emphasized that the measure has been a consequence of the previous exercise of her right to freedom of expression. The court also analyzed and noted and concluded that the interference of the Romanian state had been prompted by the views and criticisms that the applicant, meaning Laura Codruța-Kövesi, had expressed publicly. And if we can move to the next slide, the court basically noted that expressing the views and opinions on the judiciary system is, if I may say it like that, part of the job description of any prosecutor. So the court actually attached particular importance to the office held by the applicant and noted that her functions and duties imposed her to express such kind of views. Also, the court went further and noted that the views and statements made by Laura Codruța-Kövesi in her capacity as chief prosecutor had not contained attacks against any other member of the judiciary, and also it did not imply or contain or concern criticisms with regard to the conduct of the judiciary when dealing with pending proceedings, which it might have been debatable if that it falls within the limits of freedom of expression or not. The court has also noted that her statements had not gone beyond mere criticism from a strictly professional perspective. So as a conclusion, the European Court noted that her position, her public statements fell within the context of a debate on matters of great public interest, which consequently called for a high degree of protection for her freedom of expression, and which also implied a narrow margin of appreciation being afforded to the authorities of Romania as the respondent state. The court introduces very interesting principle, I might say. It talks about the chilling effect that the removal measure, which was the most severe sanction that could have been applied in Laura Codruța-Kövesi's case, the chilling effect this measure had not only on her personally in her capacity as chief prosecutor, but also on any other prosecutors and judges that would have been discouraged to engage in any public debate regarding legislative reforms affecting the judiciary. Also, the court held that the removal from the office was not a measure necessary in a democratic society within the meaning of Article 10. The judgment of the European Court has had an earthquake effect in Romania, and it has been generally perceived as a benchmark in all legal matters related to the freedom of expression of prosecutors and judges, magistrates, generally speaking. This judgment has been extensively cited in other case law of the court and regarded as an important ruling of the court. Now, I want to show you the impact of the judgment of the European Court on our national legislation. So while Laura Codruța-Kövesi held the position as chief prosecutor in 2018, the following provisions were in force, and you have them on the slide. Judges and prosecutors are obliged in the exercise of their duties to refrain from any defamatory manifestation or expression, and which is debatable, what is defamatory, what is not, in any way against the other powers of the state, legislative and executive. What is very interesting is that the Venice Commission had expressed its opinion and views on these particular provisions in 2018, so 2 years prior to the judgment of the court. And the Venice Commission considered these provisions, legal provisions, as to be unnecessary at best and dangerous at worst. And the Venice Commission outlined that the restriction imposed to judges and prosecutors in the manner above may be seen as problematic under Article 10, and it should be therefore it should be deleted. Further to the judgment of the European Court in case Kövesi, those provisions imposing restrictions on judges and prosecutors have been eliminated from the national legislation. That happened in 2022. Also, the legislation was improved in the sense that the principle of prosecutors' independence has been reinforced in the national legislation. The current legislation, which is has been enforced since 2022, also expressly states that prosecutors are independent in accordance with the law. And next, a new update of the national legislation consisted in the fact that the freedom of expression of prosecutors has been expressly provided in the current applicable legal framework. The provisions state that magistrates, so judges and prosecutors, may express their opinions regarding public policies or legislative initiatives in the judiciary sector or other domains of public interest, provided that such have no political character. And the great merits for these legislative changes go to two associations of prosecutors from Romania, which I have indicated in the following slide. If we can move to the next slide. These two associations, the Romanian Judges Forum Association and the Association Initiative for Justice, those were the ones that made all the efforts to improve the legislation based on the judgment of the European Court in Kövesi case. This was my presentation for today. I thank you for your attention, and I'm here always for further debate or any kind of intervention.
Isabella, thank you very much. I think. Okay. I think you've heard the applause from the room, so that was absolutely well deserved. Mulțumesc, if I'm.
Thank you.
Mulțumesc, yeah, mulțumesc. I'm pronouncing it correctly, and now I also know that we have a participant from Romania, so mulțumesc. And now it's time for Mohor. Just a short information for our technical team. Okay, Mohor, I think you are the co-host now, and you can present your slides. Check whether it works.
Okay, thank you, Jaroslav. I'll try to check it immediately. So let's see if it works. Can you already see the slides?
We see.
Do you see the slides? Yeah. Do you see it changing as well? Okay, I think. Yeah. Okay, great.
Mohor, it works. Don't worry.
With those technical issues. So thank you, Jaras, for the invitation. First of all, I'm very happy and grateful to be here, even though it would be better to be in Warsaw than in otherwise sunny Ljubljana Friday afternoon. So without further ado, I would like to present my my thoughts on freedom of expression of prosecutors. As Jaras already mentioned, in March we organized at the University of Ljubljana a similar seminar, a workshop under Trial 2 project, which was entitled Freedom of Expression and Association of Judges. So the main question of my today's presentation is whether we can use the standards developed for judges, for freedom of expression of judges, also for freedom of expression of prosecutors. My presentation actually consists of two parts. In the first part, I will pose this very interesting, intriguing question. And then in the second B part of the first part, I will try to find some justifications for such an approach. And then in the second part, I will present a few the topics that we've dealt with in the Ljubljana workshop, the preparatory materials that we had, the booklet, and I'll try to be like 20, 25 minutes. And please stop me if I'm too long. So let's go immediately to the first part. So the question is whether the standards concerning freedom of expression of judges are applicable as well to freedom of expression of prosecutors. So first of all, why is this a relevant question? And perhaps one can give you a quantitative answer at the first. The quantitative answer is that we have these many cases of freedom of expression of prosecutors under Article 10, and we have these many cases of freedom of expression of judges under Article 10. So it might be useful if we can, as prosecutors, use and apply also the guiding principles that were developed in cases of freedom of expression of judges, which are many more than freedom of expression of prosecutors. So this is perhaps the quantitative reason, and the second is a more qualitative reason, and is also a raison d'être of my second part of the presentation, which is if we say that freedom of expression standards for judges cannot be used for prosecutors, then it's useless that I go to the second part of my presentation, which will be on freedom of expression of judges and what we discussed in Ljubljana's seminar. So it better be possible to transfer those standards from judges to prosecutors, otherwise I might not be the best speaker. But anyways, so generally speaking, the general approach of the European Court of Human Rights in cases of freedom of expression is that it uses a functional approach, which means that actually different professions, different applicants have different standards against which their freedom of expression is evaluated by the court. So if we're talking about, I don't know, lawyers, if we're talking about judges, if we're talking about, let's say, teachers or journalists, we have different standards among these categories of applicants. Why? Because each of these categories has a special role in the democratic society. So the freedom of expression of standards are actually very much dependent on the role that the court assigns to each of those categories in the democratic society. And if we are talking about prosecutors, we can say, of course, that the role of the prosecutors is not entirely the same, but at the same time, not entirely different compared to judges. So this general approach can give us some, let's say, the ground to start our discussion with, but it does not give us the final answer to the question posed in the first part of my presentation. So let's have a look at how the court actually has dealt with this dilemma in the jurisprudence. And the jurisprudence actually so far is very positive in the sense that the court actually treats prosecutors equally to judges in cases of freedom of expression. And I'll give you a few examples. So the first is when you're reading ECHR case law on freedom of expression of prosecutors, you always find so many references to previous cases concerning judges, and vice versa as well. So when you're reading cases from of freedom of expression of judges, you can also find cases of prosecutors. And from the presentation of Isabella Della Popa, which was really good, she also mentioned that the Koveshi case, a case concerning a prosecutor, is often cited by the court even in cases of judges. And I'm grateful to my previous speaker because she has done a wonderful job presenting the Koveshi case. And in this case, actually, if you would read only the general principles on freedom of expression, in this case, they are in paragraphs 200 to 203, and you would not know that this case is actually about a prosecutor. If you would read this, you wouldn't know, actually. So it's just full of references to freedom of expression of judges' cases. And this is yet another example or a sign that the court is using the standards from judges' freedom of expression in cases of prosecutors. And if we go one layer deeper into analysis of this Koveshi versus Romania, I would just like to pinpoint some ideas that were actually similar or practically the same as in the freedom of expression of judges leading case Baca versus Hungary. So one of the elements which was already mentioned by the previous speaker was this causal link between, so the fact that who had to establish the causal link between the public expression of the opinion and the sanction that followed. Actually, the court in Baca, which is, to my knowledge, the first case when this shifting of burden of proof is done by the court. In case of Baca, the court says, well, the applicant just has to prima facie show that there was some sanction because of the publicly expressed opinion, and then the burden of proof shifts to the state, and this element is actually the same in the Koveshi case. And then again, in Baca, the court found no legitimate aim of the interference with freedom of expression, and the same was found in Koveshi for practically the same reasons. And then, even though there was no legitimate aim, and the court could stop at this very moment and say, well, this is a violation of Article 10, the court goes on and says, actually, it's not necessary, but we'll do it. We'll try to, we'll give you the guiding principles and decide the necessity test, even though it's not necessary in both cases. And then, as the previous speaker has already said, in both cases, Koveshi and Baca, the narrow margin of appreciation is accorded. And finally, the chilling effect. In both cases, the court uses very strong words. It doesn't say it might have a chilling effect or it could potentially have a chilling effect, which is what normally the court finds in such cases. It said in both cases, undoubtedly, it had a chilling effect. So you could see, if you compare the two cases, one is from a freedom of expression of judge and another a prosecutor, but you can see very clearly, and this could be a case study for the claim, that freedom of expression of judges and prosecutors is treated alike in Strasbourg. And Imagaoglu, another case which actually is about the public prosecutor who, during the disciplinary proceedings that were triggered against him for public expression of the opinion, he turned out during this disciplinary proceeding, he became a judge. He used to be a prosecutor. And for the court, this didn't change at all the treatment of the case. But actually, if you read carefully this Eminagoglu, I don't know how to pronounce it, case, you can see that it actually, here is the point where the things might get a bit complicated in terms of our research question of my presentation. Because in this case, in paragraph 125, the court also says this. Considerations applicable to freedom of expression of judges may also apply mutatis mutandis to prosecutors in Turkey, as the Turkish judicial system does not make any fundamental distinction between the status of judges and prosecutors. So we might wonder, a contrario, does this mean that when in a member state or in a state, the judicial system does make some substantial difference in the status of judges and prosecutors, does this mean that actually standards from judges cannot be transferred mutatis mutandis to prosecutors? Well, a leading scholar in this field, Sietske Dijkstra, she's a judge in the Netherlands. She has published a PhD on freedom of expression of judges. She says something along these lines, that actually the cases of prosecutors' freedom of expression are dealt by the court within the lines of freedom of expression of judges. But then she also says that there is another reference that could be used also to argue differently, and this is the Goryainova versus Ukraine. Again, I'm not sure whether I pronounce it correctly. And Sietske Dijkstra, she argues that that this case actually warrants the conclusion that a differentiation between judges and prosecutors may be relevant when the national legal system does not regard the protection, the prosecution authorities as part of the judiciary. So the question is, can we actually transfer standards of freedom of expression of judges to prosecutors only in countries where we have a comparable status of judges and prosecutors? And to this answer, to this question, I don't actually have a final answer. I can only say and admit that actually when you're looking at which were the countries from which the cases of public prosecutors' freedom of expression came from, they were actually mostly countries where judges and prosecutors have quite a similar status. You know, they are both magistrates. So this is Romania, Turkey, and Moldova. I'm not an expert on status of prosecutors in those countries, but from my very understanding, I think that there is like this statuses can be compared more than in other countries, like, I don't know, Germany, for example. So yeah, the question is, should the court continue to apply equal standards in cases of freedom of expression of judges and in cases of freedom of expression of prosecutors? I would argue for the application of similar standards. And this brings me to my B question of the first part, which is, what is the justification for treating judges and prosecutors' expression similarly alike? So the first is given by the court in Eminagaoglu case, which is similar status under national law of judges and prosecutors. This is one argument. Another argument is that prosecutors' tasks are sometimes very similar to those of judges. Let me give you a few examples. So, for example, when the prosecutor decides whether to continue the prosecution or just to dismiss the criminal complaint. In Slovenia, there was a few years ago an article of our former prosecutor general who argued that this is actually a adjudicatory role, that prosecutors are acting like judges in these cases, and that in 2/3 of all criminal complaints they are dismissed without going to trial. So this is one example. And the other one is, of course, that prosecutor orders measures interfering with human rights. For example, the initiation of the criminal procedure itself can have effect on human rights. They also order secret or unsecret investigation measures that interfere in the human rights. So their role is, as one of the previous speakers also mentioned in this panel, to guarantee fundamental rights. And this is the same as with judges. And moreover, yeah, the prosecutor proposes sanctions. It also does plea bargaining. So there was one case, an example in Slovenia, when a public prosecutor signed a petition against a Dublin return of an asylum seeker from Slovenia to Croatia. And years after this signing of a petition, the government-friendly media found that this very same prosecutor proposed a really lenient sanction for another refugee who assaulted a taxi driver in Slovenia. So you can see that from this case that this is very similar. Then you could use the same arguments to disqualify a judge in this case. So yeah, another example. And then another argument could be that prosecutors also deal with politically or otherwise sensitive cases, and that it's really important that they are regarded as independent and impartial by the public at large. They deal with corruption cases. This was also one of the examples from Slovenia when a priest was actually put in a criminal procedure because he said something really bad about people who supported abortion. And he was, and then there was this whole great debate about whether it was okay to put him into criminal procedure or whether this violated his freedom of expression. So again, prosecutors have powers and deal with very sensitive cases. So it's important, really important for the public to see them as impartial and independent. And I think that at least a certain level of independence of prosecutors is required in all members of the Council of Europe. It can differ from country to country, but a certain level of autonomy of public prosecutors is a basic, let's say, fundamental premise of the rule of law, in my opinion. So yes, I think there are many arguments that argue for a similar approach between judges and prosecutors' freedom of expression. So the conclusions from the first part is that when we have countries where prosecutors have similar status to judges, the equal treatment of judges and prosecutors is already something that is part of the, let's say, minimal standards of the Council of Europe through the jurisprudence of the ECHR. In other countries, we have other arguments for equal treatment of judges and prosecutors' freedom of expression. But of course, circumstances of the case are key here. And one of the circumstances that the court regularly highlights is the position of the applicant. And of course, there might be some differences if an applicant is a judge or if he or she is a prosecutor. Similarly, then, when we compare judges who judge at the first instance or the Supreme Court judges, there might be a little bit of a difference in approach of the ECHR. So this is the first part. So the second part, and I'll quickly skim through just to give you an impression what were the key topics, takeaways from our seminar in Ljubljana on freedom of expression and association of judges. So this is first part of the program, first panel. We had Madalina Moralu, you've met her today. And why I'm going through the program, because in the coming days, the recordings from our webinar will be, from our workshop will be available. So you will be enabled to see them as well. So yeah, I think it's important just to give you a glimpse of what we did in Ljubljana, because it might be useful also for freedom of expression of prosecutors. Yeah, so we had Madalina Moraru, then we had a judge at the General Court of the European Union, Dr. Kukovec. He presented his views on freedom of expression and of associations of judges at the Court of Justice of the EU. Then we have a really interesting presentation of Paulina Milewska, who's a PhD candidate at the EUI, Department of Law. She was talking about procedures against judges that have elements of SLAPs, so strategic lawsuits against public participation. And then we had the already mentioned Sietske Dijkstra from the Netherlands, speaking about another aspect of freedom of expression of judges, which might not be as relevant for the prosecutors, but nevertheless. So the perspective of the parties when the judge expresses freedom of expresses his opinion, how this impacts the impartiality of the trial, whether it does, it does not, it can or it cannot. So the second panel was more devoted to wider considerations and the role of freedom of expression of judges and association in the rule of law backsliding context. We had Agnes Kovac, who discussed the reasons for the low voice of Hungarian judges and the role of European courts in supporting the Hungarian judiciary. We also had a presentation of Raluca Bercea from the National Association of Romanian Bars, and she presented the very important role of the judicial associations in preventing the rule of law decay in Romania. And then we have a political scientist who gave his perspective on judges in the times of rule of law crisis. And this might be also interesting for prosecutors. And then the third panel was devoted to social media. And this was really, I think, the best panel. We had a presentation, a very academic one, from Janika Jan from the Max Planck Institute. Then we have the convener of this conference, Jaroslav Gwizdak, who presented how in Poland judges used social media, especially Twitter, in the times of rule of law crisis. And then a very useful presentation from a Dutch judge, former president of the European Network of Councils for the Judiciary, who gave really his first-hand, not only impression, but how he uses social media. He explained what are the do's and don'ts of social media through his experience. So yeah, I really recommend this his presentation. And then we have perhaps another perspective which is also important, a perspective of a senior judge from the common law jurisdiction. And this presentation really opened the eyes for how differently judges in different settings, national settings, look at the same issues. Because Judith Gleeson, the judge from London, she was really reluctant. She said, well, in the UK, the only person who speaks publicly is the Lady Chief Justice. And we try to avoid as much as possible any expression, especially political expression. We do our job. And then she was confronted with the question, well, what about in cases where the Lady Chief Justice does not react? But then, well, we haven't got these cases yet, but we don't know. So you could see that there's really a different of difference of perspective based on the national experience of each member state. So this makes this topic very interesting, in my opinion. And then we had a final roundtable session, which was devoted to representatives of the judiciary. So what's the role of, let's say, members of the presidents of the judicial associations or PR services of courts. And we had also three very distinguished speakers that you can see on the slide. And I know I'm running out of time, so I'm coming to my conclusions. Before I do that, we had also two hypothetical case scenarios that might be interesting also for prosecutors. The first one is whether and how to apply the whistleblowers directive in cases of whistleblowers from the judiciary. And then the second one was based on the muzzle law decision of the Court of Justice. We focused on the freedom of association of judges part. And then the thematic booklet of freedom of expression and association of judges also contains many references to cases of public prosecutors and other, I don't know, public servants, because you can also, of course, sometimes rely on some cases of other public servants. And then another useful training material might be, and you'll also be given access to this, is the list of cases that I already presented in my presentation. And yeah, you can perhaps use, you can find useful these as well. So I think I've talked more than enough, and I thank you for your attention, and of course, once again, for the invitation, and I'm open for any questions. Thank you.
Thank you very much, Mohor, for your presentation and also referring to this judicial freedom of expression and also making some product placement about the recordings from the seminar in Ljubljana. We really appreciate this, and it's really important for the whole Trial 2 project. It's amazing because we are having half an hour for the discussion, so yeah, just if there's anyone joining us online, so probably online first, for some question, comments, some doubts. I just wanted to remind you that we started with a short introduction of the Polish Deputy Minister of Justice Dariusz Mazur. Then we had this amazing presentation done by Paweł Pik, another amazing presentation about the Kövesi case, so we just know what exactly happened in the Kövesi case. And then we had also Mohor speaking about what do judges and prosecutors has in common, especially when it comes to the freedom of expression. And we have already Jakub Jaraczewski with us, so the guy for tomorrow. So he will, I think, complete what Mohor started also with the association and with this fisherman cases, or just the problems that the judges and prosecutors have. So are there any questions from our online guests? Any, just raise your hand, please. But I can't see any hand raised so far. Okay, no question. No comments so far. So, what about people in the room? As you have the also unique opportunity maybe to discuss in details the question of secondment, the question of what happened to the prosecutors in Poland, because we have them here, so, and I think they are also open to share their experience. So any questions?
May I?
Sure, we have the question from the speaker, so Paweł starts.
Yeah, because I've got a comment, maybe not a question, on Mohor presentation, because it was very interesting for me. I would like just to share an example from the Polish grant, that we had a colleague, a prosecutor, against whom the disciplinary proceedings were open just for participating the protest against the violation of the constitution in Poland. He didn't say a word. He was just present, standing in the street, and the management of the public prosecution service opened disciplinary proceedings against him, and there was an indictment in a disciplinary proceeding. Luckily, he was found not guilty by the court, the special court for the prosecutors, but anyway, it was just a very long and retiring disciplinary proceeding against him. Thank you.
Well, I think we can treat it also as okay. We have also Jacek, so maybe comment, question, whatever. So Jacek has a mic. So okay.
I want to clarify what Paweł said, because he not just stand and participated in the protest, but according to secondment, he said, "What can they do to me? They can second me to Ełk. Ełk is very far from Warsaw. It was in Warsaw, and only that statement in the press article was the base to instigate disciplinary proceedings against my colleague."
Okay, so yeah, the floor to our friend from Romania.
Thank you so much. So I have two comments. First, you said in the presentation of your Deputy Minister of Justice that he is a legend here in Poland. Well, he is also well known in Bucharest, because, sorry to speak in absence, but he was also present in Bucharest in March 2019, supporting the judges from Bucharest while they were raising concerns about the judicial reform happening back then in Romania. That was my first comment. The second comment, it is about the Kövesi case, of course. I think we all know that Madam Kövesi was not only raising public concern about this judicial reform, but she was also a quite effective prosecutor. And the main reason why the Minister of Justice wanted her to be dismissed, it was particularly this one, because she, as a prosecutor, investigated numerous many cases of corruptions against, of course, politicians. And you also know that nowadays, Madam Kövesi, it is a European prosecutor. She's investigating 2,000 cases of corruption against, of course, a European budget. So Madam Kövesi was too good for Romania. She was dismissed, and now she's a European prosecutor. So thank you.
Okay, thank you very much. I don't need to say that I'm jealous that Darek is also a legend in Romania, not only in Poland. So Poland is too small maybe for him and for his legendary achievements. So for our speakers, do you want also to comment those comments? Because what was said by Prosecutor Bilewicz and Prosecutor Pik, so we come into kind of the absurd, setting that the prosecutor, whatever he does, he's probably in danger of disciplinary procedures. And I just wanted to remind also, we have this March of Thousand Ropes when we have prosecutors and judges on the street, and it's probably something we also heard about the court president that arrested the ropes, that the judges couldn't use it. And yes, so that's speaking about some absurd also in the moment that the judges and prosecutors, they are gathering on the street, sometimes saying nothing. So what are your comments on those issues?
If I may, it was, I think, the biggest march of the lawyers in the whole European Union, in the whole Europe probably. There was not such a march in the history of the judiciary. And to be honest, what we have learned, what was really good in that really difficult period, that we judges and prosecutors, we decided to leave our offices just to try to talk with people, just to share our interest, our opinions with the people, with the NGOs, but also with the ordinary people in the street. And because we lawyers in Poland, when the communist system collapsed, we forgot to explain to the people why the independence of the judges, why the independence of the prosecutors is important for them, for the ordinary people. And that was the problem. And what good had happened in that period is that we judges, we prosecutors understand that problem, and we started to educate people, to talk as much as possible about the independence of the judges, about the constitution, about the law, why it is important in the democratic state. So this is that little bit of good that was in that really difficult period. Thank you.
Okay, so now for another speakers, just Isabella and then Mohor just for the comment. If there are no further questions and comments here in the room or online. Isabella, please, the floor is yours.
I have only one supplementary opinion just to say regarding the comment made from the seminar on the Kövesi case. I do agree on what was said, that Laura Codruța Kövesi was known as a very effective prosecutor. But with respect to the judgment of the court, I stress the need to remain to the freedom of speech, to the freedom of expression. I do believe that if we add up, additional spices to the story, it's like we take effect from the judgment of the court. The court noted that her views and opinions publicly expressed were within the limits of freedom of expression and should remain as such. Otherwise saying, if we consider the Kövesi case as a particular case, given the fact that she was extremely efficient and she was renowned as a very good prosecutor, that would mean that in case of a less known prosecutor, the same would not apply. Well, it does. And that's why I would keep this line of reasoning. It is true, and I don't know if that is known or generally known, that multiple disciplinary actions were opened and carried on against Laura Codruța Kövesi, mainly based on the fact that she was a very efficient chief prosecutor. They also claimed, for example, as part of the disciplinary actions, that she was pressing her subordinates, the rest of the prosecutors, to speed up some proceedings or to be more efficient, and they consider that as being against the law at that point. But in terms of freedom of expression, I would limit the discussion to what was effectively noted by the court in its judgment. And I honestly believe that the same applies for the Turkish jurisprudence. We are all aware of the social and judicial system from Turkey. So some things are so well known that do not need to be stressed. And yet we need to address each and every particular case given the facts that are brought to European Court of Human Rights for judgment. That's my only comment. And thank you. And I look forward, Mohor, for the online recordings of the seminar. Thank you so much for the recommendation. You've done a wonderful job. I'm eager to watch them all and to see the presentations that were held in Ljubljana. And also thank you for the centralized case law, both for judges and for prosecutors. That's of great help for further research. Thank you.
Yes, definitely. All the presentations will be also available on the project website, and there will be kind of the e-learning course also. So, and you will get access to it, I think, till the last day of our lives. So we will have it. Okay, Mohor, now it's time for your comment.
Thank you, Jaroslav, and thank you also to Isabela Delia Popa for kind words. Yeah, this is what is our job. We try to make life of academics, practitioners easier by giving good training materials and other kinds of materials. So perhaps two comments. The first one is on the case mentioned by Paweł Pik on a prosecutor from Poland. You said that, yeah, the case actually didn't lead into a condemnation or something. But yeah, as I would just like to stress that even though there was no final condemnation, the fact that you're put in a disciplinary proceeding, as probably, unfortunately, some of you know from personal experience, can make you suffer. And this is, yeah, the purpose of such proceedings. But the problem is that at the ECHR level, such cases really, first of all, don't come to the ECHR because people don't perhaps they don't consider these cases useful to be presented before the ECHR. They think they're not strong cases. And the second reason is, and I'm researching on this issue as part of my PhD, is that the court really tries to keep the doors to Strasbourg shut, more or less, or at least just left it ajar in this kind of situation, because it says, well, of course there might be a disciplinary procedure, but in the end nothing really happened to the person. There was no condemnation, so there's no really the problem of victim status clearly emerges here. So there is actually, I think, a big need to get some strategic litigation on these issues to the Strasbourg court, because as the law stands now, it might happen that some member states can go away with such, let's say, strategic lawsuits against participation of judges and prosecutors. But there are, of course, also some cases, for example, the Tuleya case, you all know very well, where the court explicitly notes this, that the judicial inspectors had so much power and so much latitude how to use these powers, that this was actually a violation in itself, even though irrespective of the outcome of the disciplinary procedures and other procedures against Judge Tuleya. So we have also some cases where the court was a bit stricter, and that kind of, they are a sunshine of hope for this kind of situation. And the second comment perhaps can be on the Kovesi versus Romania, and also on Baca versus Hungary, because especially Baca versus Hungary was criticized in academia as failing really to grasp the essence of the case, because they say, some academics, David Kosarz and Katarina Shipulova, for example, they say, well, the essence of the case was judicial independence. It was not freedom of expression. Freedom of expression was actually just an avenue how to get the case before Strasbourg. Because, why? Because you cannot plead a violation of subjective judicial independence in Strasbourg. There is no provision that would give you such an opportunity. So you must always find another provision, let's say freedom of expression of judges, but also the right to privacy, or I don't know, another convention right. So you can frame it, frame your case as a violation of one of these cases, even though your independence as a judge or a prosecutor is actually the central issue of the case. And there is some, in the Baca case, actually, one of the judges from the ECHR proposed a solution to this problem, and this would be a subjective right to judicial independence, so that the court would recognize that each judge under Article 6 of the Convention can claim that this article gives him or her an individual right to judicial independence. But for now, actually, the only way to Strasbourg to defend your independence is actually through other provisions of the convention. And as I see the Kovesi judgment, it's also can be understood in this sense. You could say that actually the independence of the prosecutors is the central element of this case, but actually to get this case before the ECHR, you would have to present it as a violation of freedom of expression, because otherwise it would just not go through. Thank you.
Thank you very much, Mohor. There is a comment again from the room. Prosecutor Bilevich, please.
I want to comment on the topic you mentioned. I mean the secondments of the prosecutors, because you have to know that the situation in Poland concerning the prosecutors and the judges are very different, because in fact there are guarantees for the judges, and the judges could not be transferred or could not be on the secondment, but concerning the prosecutors, in the March of 2016, 124 prosecutors were permanently transferred. They were in fact demoted one level or two levels, and I'd like to present the example of our first president of the management board, because he was the experienced prosecutor in the National Prosecutor's Office, prosecutor from the highest level. He was demoted to the lowest level, and all of his career was questioned by one decision without any explanation of the prosecutor general. And according to the secondment, you have to. Pavel mentioned the utility. I mean the carrot and the stick, and you have to look at the secondment not only as a stick, but also as a carrot, because those demoted prosecutors were replaced by the young, not experienced prosecutors who were promoted on their positions. I mean, positions, professional positions of demoted prosecutors, and I think it was, of course, a very hard time for us. But many young prosecutors look at those times as an opportunity to be promoted. So I think it is the reason why we were only 300 prosecutors association. And also you mentioned about the disciplinary measures or even penal measures, which were the subject. I also have to tell you about one strategic lawsuit those slap was initiated against our second president of the management board, Ms. Katarzyna Kwiatkowska. She is with us on this seminar, and you have to know that she gave an interview to the newspaper. And of course, she said that the method of the carrot and the stick is in fact the tool of the institutional corruption of the prosecutors. And she mentioned that we are collecting evidence concerning the prosecutors, and in the future we will instigate the penal or disciplinary proceedings against those prosecutors. And you have to know that the chief of the National Prosecutor's Office, the National Prosecutor, initiated the civil action against Ms. Kwiatkowska, and because, in his opinion, she infringed the dignity of the National Prosecutor's Office. Not the dignity of the National Prosecutor, but the dignity of the office. And he demanded to pay 250,000 Polish zlotys. And of course, he demanded from Ms. Katarzyna Kwiatkowska to give some explanations and to withdraw her words about what is the current situation in the Polish prosecutor's office. And I have to mention that it was really a happy day for me when I was acting as a national prosecutor, when I withdrew that suit. Thank you very much.
So I think the statement of the former acting prosecutor general can be the wrapping up of the session, if you allow me. So now we will have a break and we will reconvene at 6:15. Okay? So also thanks a lot for our speakers, our remote speakers. Thank you very much for your enormous contribution, and see you then. Thanks a lot. Halo, halo Łukasz? Halo, halo? O, za chwilę będziemy gadać, widzę. Widzę cię, widzę cię. Halo, halo. Jak mnie słyszysz?
Bardzo dobrze. I teraz właśnie...
To możesz sobie jeszcze przepróbować slajdy. No cudownie. A czemu ty jesteś w takiej sepi, taki nostalgiczny? Cudownie, tak, wszystko.
Sepia jest dla mnie
Sepia wyszczupla.
twarzowym kolorem.
Sepia wyszczupla, to jest to. Dobra, nie no, pięknie.
Raczej odróżany.
A, odróżnienie. Słuchaj. Za jakieś 2 minutki będziemy działać, ale już możesz tutaj na nas patrzeć. Znaczy, tak nas nie widzisz. Dobra.
Ale to jest, wiesz co, to jest bardzo ciekawe spotkanie.
To jest mało powiedziane.
Tak, także żałuję, że nie byłem od początku. Że nie
Dostaniesz wszystko, poza
tym.
tym... Łukasz, nagrywamy to, także wszystko będzie do zobaczenia. Poza tym myślę, że będzie takie całe repozytorium tego naszego triala, także trochę czasu i tam zrobimy fajną telewizję. Wszystko jest, wszystko jest.
Mnie też będziecie nagrywać? Halo?
Okay, so it's 15 past 6 or 18:15 as they say in United States. So please let's take a seat. Take a seat and just keep your breath. Keep your breath because we are expecting another enormous presentation from Łukasz Bojarski. So zarząd, żeby usiadło państwo. Gadają cały czas, nie słuchają. Naprawdę.
Informacja, że ja to puszczę, czy mogę dać znać informację, że puszczę?
Dobra, to daj znać. Okay, so our next speaker is Dr. Łukasz Bojarski. He just defended his PhD thesis at the University of Oslo. And speaking about legends, so you've already seen Dariusz Mazur, one of the Polish and Romanian, as I learned today, legend of the judiciary, of the independence of the judges. So now we will have the great pleasure and the great privilege to listen to another legend, so the legend of the civil society organization, the legend of court monitoring, and especially the legend and the founding father of our foundation, of the Institute for Law and Society, the think tank. So Łukasz was one of the founders, and it was almost exactly 15 years ago when he decided that the legal think tank is something that Poland really needs, and he just started doing it. He was also the member of the National Council of Judiciary, one of the first and the only probably member coming from the NGO. And now he's in Norway. Don't ask me why, and don't ask him why he's in Norway. So Łukasz Bojarski and his presentation about the lessons learned on judicial resistance in Poland. What about prosecutors? So as I counted already, we've heard, I think, twice this mutatis mutandis, but I hope in Łukasz presentation we will have mutatis mutandis quite a few times. Łukasz, the floor is yours.
Thank you very much. Can you hear me well?
Yes.
Can you hear me? Okay. Can you see the presentation?
Yes.
Fantastic. Good afternoon, everybody. It's a big pleasure to be with you. And I only regret that I couldn't join you from the very beginning, but from what I've heard during the last half an hour of the discussions, I'm sure that I will reach to those presentations and to those recordings later on because it's extremely interesting. As Jarosław said, I was working on my PhD project that was called Judicial Resistance Against the Rule of Law Backsliding, Judges and Citizens, the Case of Poland. So I was focusing on judges, but after presenting to you my idea that I created, kind of concept that I tried to elaborate during this project, and after, I will try to ask you whether we can compare this situation to the prosecutor situation or not, and ask for your opinion about it. So I hope to speak for no more than 30 minutes, so we have enough time for our discussions later on. I wanted to, I cannot change. Hannah entered, admit. So you gave me the right of the, sorry, I cannot change, I don't know why. Okay, okay. So I wanted to start from the, scratch, from the very beginning, just to let you know, kind of, and to show you and to prove you that I'm looking at these issues from the perspective of the citizens. Of course, for the last couple of years, I was an academic, but my point of view is rather citizens' point of view, since I've never been judge, never been prosecutor. I'm the law school graduate, but always worked for international organizations, for civil society organizations, for think tanks, etc. And the basic question from the citizens' point of view is, why do we need courts at all? And why do we need judges? And the answer, it's not that obvious. And this is something that shows the development of the situation, because the first answer is that we need courts and judges to help us solve life issues, objectively, impartially, different kind of issues, civil, family, inheritance, contract, whatever it is. When you ask people on the street what are their affiliations they have, when you say law, they usually say criminal law, because this is what media is presenting. The good news is a bad news, crime story, organized crime, etc., etc. And people tend to forget that the law is not about criminal law. The law, and usually 90% of cases in court systems are about different fields of law. So, but this is something that is obvious, that courts are to solve life issues. But what is not so obvious, especially in our tradition, is that courts are also to protect our rights and freedoms, our fundamental rights, and courts are also to control other branches of the government. So, which is kind of not logic, because they are the part of the government. They are one of the branches of the government, if we look at the tripartite concept of division of powers. But there are this power that is to control other branches of the government. And this is something that we started to learn, in fact, after the democratic changes have started, because before we didn't look at law from this perspective. I remember when I went to the United States in like early 90s, one of the first questions that I was asked at kind of liberal College of Law, the Washington College of Law, American University in Washington, D.C. was, Łukasz, how do you sue the government in Poland to the court? And I have to admit that I was kind of surprised that that was the first question that I was asked, and I didn't have like an immediate answer. Of course, after I gave it some thinking, it was obvious that you have constitutional tribunal, you have the ways to challenge the government in court, but it has proved to me that how different you can look at the law, you can look at the procedures, that this American concept of lawyers being the engine of social change is something really rooted in their society. For us, it was traditionally rather local leaders, rather politicians, that were engine of social changes, not lawyers. And however, it is changing, as we all are aware, in the last 30 years. And what more, in the recent years, judges joined this movement and started to challenge the government, challenge the state in the courts themselves via strategic litigation, etc. What courts do we need? We know for what we need them, but what kind of courts do we need? What is the court of our dreams? This is a concept of judicial capacity developed during one of the projects during the accession process. Actually, And I really like this kind of definition, so I like to share it because it's very concise and it's very deep if you think about it. So what is the court of our dreams? The court that is independent, competent, so professional, accountable, so transparent, and efficient. And it's important that those elements are balanced. If the court is totally independent but not competent, this is probably not good, yes? But if the court is competent but not independent, this is also not good, not to mention accountability. We tend to focus in Poland during the first years after the changes and on independence and efficiency. So independence was very important to secure independence, but the second one was efficiency, to deal with this workload of the courts, to deal with those millions of cases. We were always talking that there's a permanent crisis of the Polish judiciary, that the length of the proceedings is horrible, number of complaints to the European Court of Human Rights regarding delays, etc., etc. So we are focusing on those issues, and it's important to remember that we shall focus on all those issues. And I think that this is something that fits the prosecution office very well as well. Of course, in Polish situation, the question of independence is a tricky one, and since the prosecutors unfortunately don't have a position strong enough as compared to judges, but I think that this works really well also for prosecution. And this importance of one of those elements, the independence, is very much underlined in the Polish Constitution. So I don't want to spend time on this, but just to show you that we are using in Polish Constitution four different adjectives to underline that the courts are separate, that the relations in between powers is balanced, that courts and tribunals constitute a distinct power and shall be independent of other branches of power. So in theoretically, this is a very strong constitutional safeguard. However, as you know, during the last 8 years, we went through the very serious crash test of this concept and of this constitutional guarantees after the 2015 autumn election. The new majority came to power, and they declared that Poland needs a revolution. Actually, they were even declaring that this is the first democratic moment after the communism. They were claiming that they're gonna fight with communism, 30 years after the transformation. So of course it was ridiculous as well, but actually very serious. And since every revolution needs an enemy, one of the first enemies of Polish revolution was decided that there were judges. And this is the poster from the hate campaign against the judges on the right side, and on the left side, very famous cover of the Daily Mail from England. We would say that the country with a very long tradition of respect for judiciary, of trust, etc., etc. Even in the UK, after one of the cases regarding Brexit, this kind of cover was published, judges as enemies of the people. And in a way, this movement of undermining judiciary and judges by different populist parties spread around the world. In Poland, the government took step-by-step strategy in attacking independent institutions. The red ones are the institutions that were totally taken over. The half-red one or pink one are those that were attacked but not totally taken over. And the black one are those that were more or less that survived. So it started with prosecution. So the prosecution was the first one to be captured by the government. And as you know, previously the prosecutor general was independent, and It was combined again back with the Minister of Justice. Then public media was captured. Private media was attacked. There was a couple of attempts to close, for example, independent television, but it didn't work. Civil society organizations were attacked, and there were a couple of promises actually to even attack them further, but it didn't work. However, the government created National Institute for Development of Civil Society. Civil service was partially taken over, of course. When it comes to courts, the next line, Constitutional Tribunal was first. National Council of the Judiciary was the second. Presidents of the common courts were the next ones, changed by the Minister of Justice. And Supreme Court was also captured, but not fully. During these 8 years, they managed to have majority of the new appointees, new judges in the Supreme Court, but it's still partially independent institution. And that was very clear and very honestly, in a way, declared from the very beginning. I provide you here the quotation of the Minister of Justice, Polish Minister of Justice, Ziobro, who at the beginning of those changes said in 2016 on television, that the reform of the judiciary is ready, because he was asked about the plans of the reforming judiciary that were on the one hand announced, on the other hand hidden, secret, not revealed. So we all knew that we are expecting some big reforms, but nobody knew what. So when he was asked about it, he said the reform is ready, but it will be announced only after solving the problem with the Constitutional Tribunal. So they already knew from the very beginning that those laws that they want to introduce are unconstitutional, and if challenged in the Constitutional Tribunal, they will be held by the Constitutional Tribunal unconstitutional. So this was kind of clear. And this is what started introducing authoritarian measures that aim to limit judicial independence. And in such a situation, there are different possible responses judges can deliver. As described by academia, there are more and more interesting writings about this kind of situations. And we all probably know these terms that I listed here, what are possible judicial reactions, judicial activism. We all know what it is. Judicial opposition is more underlined by the political science researchers. They see, for example, activities of Polish judges as in a way replacing the activities of the political opposition. Judicial disobedience, of course, it's referring to the civil disobedience. So it's refusing by judges to implement a particular law, but doing it in a kind of open way and being ready to possible consequences. The concept of judicial virtues, it's developing recently, and it's underlying the virtues that judges should possess, that should be trained on, and should be evaluated based on. The concept of judicial self-defense of the institutions. This is the concept of Nicholas Balber, developed further by Polish researcher Marcin Matczak. The names below are the names of the academics that are writing about those issues. Jerzy Zajadło about judicial disobedience, Tomasz Widłak about judicial virtues, etc., etc. So this concept claims that the institutions have the right to defend themselves in an extraordinary situations. So we have number of, and there are actually much more. I just picked here the most important ones, the most known ones, but there are even more different concepts describing the possible judicial reaction to extraordinary situations. But I decided to propose something else, and I called it judicial resistance, as a concept that would combine, that would be the widest, that would combine all those previously mentioned ones. The judicial resistance, we also happen to find judicial resistance in different writings, and it has different definitions. So I decided to propose my own one, and I also decided to propose a normative model of judicial resistance, focusing on the issue whether judges have right and or duty, obligation to resist in certain circumstances. And the same follows when it comes to prosecution offices, prosecutors. We'll talk about it later. But in my, the proposition that I propose is the following. Judicial resistance encompasses actions of judges, individual and collective, in and out of court. So this is kind of categorization, typology of those methods of judicial resistance, undertaken to oppose various political activities that are aimed at undermining judicial independence and are in violation of the law. So as you see, there are a number of elements of this definition, and we can see them in more detail here. So first of all, those measures that we are resisting, that judges might resist, are political measures that aim at limiting judicial independence. I was focusing on the element of judicial independence as a kind of base, most important guarantee of the protection of the fundamental rights and control over other branches of the government, as I said before, being the role of the courts and judges. But it's also important to underline that there is, of course, a tendency also among judges, and it's been also described, but it's kind of natural tendency that when there is a proposition of the draft law that limits judicial independence, the first reaction of the judges is that this is a pure attack on independence. And we have to, in all situations that we are analyzing, we have to decide whether we are talking about this attack on judicial independence, or is it just a reform that democratic government, the democratic majority has a right to pursue. So not each attempt, not each draft law would mean attacking judicial independence. It might be really reform. In fact, the Polish changes were also called reform. However, in Polish case, we would take it in brackets. Those political measures are undertaken in breach of the law. This is also very important for me because everybody can claim that this is an attack. However, we are all lawyers and we all know that we have to refer to law, even if we resist the statutory law, we still shall refer to constitution, to international rule of law standards, etc., etc. So, in my proposition, in order for the judicial resistance to be legit, these measures should be undertaken in breach of the law. This breach should be confirmed by independent organs, in my opinion. Of course, it's not so easy and it's not so fast because, as we all know, the decision-making processes in different, like international organizations or international courts, it all takes time. So it's not immediate that when we are opposing something that we can immediately receive some kind of confirmation, objective confirmation by independent organ, be it both a national or international organ that that would confirm the breach of law. But actually, as I will show later, it is quite possible nowadays to receive something very quickly. So, for example, in Polish case, also maybe I will say it now, in Polish case, immediately after 2 weeks of some changes being introduced, several Polish civil society organizations, together with the Polish bar, sent a letter to the Venice Commission asking them to come and to report on the situation in Poland. And even if formally we didn't have standing to do it because the Venice Commission must be invited by the public body, public organ, it kind of helped to convince the government that if they claim that this is a legit reform, that they should invite the Venice Commission. Anyway, to make it short, Venice Commission came. So from the very beginning, we started to receive different statements, different opinions of different international bodies and organizations. Later, courts of courts also claiming that this is something wrong with the Polish reform, that there are some doubts, etc., etc. So for me, it's very important that this breach is confirmed. That it's not opinion just of judges or just of prosecutors, that this is not just our opinions, that we feel that we are being attacked or our independence is illegally limited. That should be confirmed. This judicial resistance, in my opinion, is very wide and includes a number of possible activities. So it's why I introduced some kind of categorization of individual resistance and group resistance. And each of those is further divided into in-court and out-of-court. And I will provide examples in a second. What is important for me, the judicial resistance includes also activities going beyond adjudicating and administration of justice. So going beyond kind of typical traditional role of judges, or in case of prosecutors, traditional role of prosecutors. And what more, I also include in judicial resistance activities that resist indirectly. So, for example, the educational project that is teaching about the role of the judicial independence or prosecutorial independence during the time of crisis, even it's just an educational project or educational activity, is indirectly also the method of resistance against what is going on around. And here are a couple of examples. I don't know, change. Okay. So a couple of examples in each category. And you can think, of course, how does it relate to the situation of prosecutors? So individual resistance in court is the resistance of the individual judge performing his or her professional duties. So it would be, for example, adjudication in political cases, yes, defending the people in those cases despite the political pressure on judges or on prosecutors to deal with those cases in a particular way, as expected by politicians or by government. It would be adjudication and asking preliminary questions, which is also kind of category, however, special category of strategic litigation that Polish judges engaged in the recent years. Preliminary references to the European Court of Justice, the Court of Justice of the EU. Another form of adjudication by simply implementing EU law as opposed to the national law. But it's also, for example, different kind of refusals or boycotts done by judges within the official procedures. So, for example, we had those situations when judges were summoned by the disciplinary prosecutor and they officially, publicly, in written form, refused to appear in front of the disciplinary prosecutor, arguing, of course, using legal arguments, why they refuse to do it, and also claiming that they are willing to appear before the disciplinary prosecutor once the situation changes, in a sense that once the verdict, the ruling of the Court of Justice of the European Union is implemented by the Polish legislature. Another example is testing the procedures. It's also in official procedures. It's obvious for Polish participants. This is what we in a common language called kamikaze trials, kamikaze judges. Those are judges that were taking part in unconstitutional or at least very controversial procedures, appointment procedures for the judges of the Supreme Court. And they knew from the very beginning that they will not be accepted, but they took part in the competition in order to test the procedures, to challenge those procedures via strategic litigation. It's why they were called kamikaze. It's because they knew that the end of the story is negative. They have no chances. But those are the examples of the individual resistance in court. Individual resistance out of court. This is a resistance when judges act as regular citizens or as judges citizens, but not in their professional capacity in court. So, for example, there are a number of different kinds of judges' lawsuits against the state. And then we have in Poland a number of different examples. We have a defamation cases against the Minister of Justice, won. We have, of course, many complaints to the European Court of Human Rights of judges. But as we know, they don't act as judges in a legal procedure. Yes, they act as kind of citizens, as private parties, even if they are judges or as judges citizens. So it's why I categorize it as out-of-court judicial resistance. All kinds of media appearances, awareness-raising activities, educational projects that judges, individual judges are involved in. We had in Poland during the last 8 years, for sure hundreds, but I would say that it's possible that we passed actually 1,000, however, I'm not sure. Of different initiatives, because during 8 years, with the number of courts we have in Poland, with the number of judges engaged, we had really hundreds and hundreds of different kind of events of this type, like visits in schools, like legal cafes, like protests in front of courts, like social media, etc., etc. And here we're talking about the individual resistance, because even sometimes it's difficult to categorize, because, for example, when we are talking about demonstration that is being organized by somebody else, not judges themselves, of course, if the judges appear in this kind of demonstration or manifestation as a group, you can call it group resistance. But in fact, each of them is taking this decision individually to appear. So it's also sometimes difficult to differentiate it. But I think that we all feel it. Naming and shaming, very interesting and very important resistance method, stigmatization and ostracism, because in the modern world, what we are witnessing is that very often we don't know the names of those who do bad things. And for example, everybody knows about political prisoners being in prison, like Navalny, for example, but nobody knows the name of the judge that sent Navalny to prison. And this is just an example that it's really interesting that even international community, we don't tend to focus on stigmatizing those who are acting illegally, even there are lawyers, judges, prosecutors, etc. So naming and shaming is very important, and it's a range of methods being used. In Poland, for example, it was starting from the calling these judges neo-judges, judges that took part in the unconstitutional procedures, appointing procedures, neo-judges, neo-National Council of the Judiciary. This was not, not greeting somebody with the hand, which is kind of traditional way of greeting in Poland, and it was even raised by one of the neo-judges in the Supreme Court who felt offended that that he's not being greeted, and he even wrote a complaint to the president of Poland that he's treated the bad way in the Supreme Court because the older colleagues are not greeting him with hand. But it's also listing, reporting on those names, on those people who are agents of this illegal system. And for example, in Polish case, this was done both by judges and by prosecutors. I'm sure you've heard about this report about the kings of Polish prosecution service, those who engaged in this attack on rule of law. in Poland. And anything that is related to freedom of expression, assembly, and association by individual people, we can, of course, multiply the examples of using these freedoms. And now, group resistance examples. Group resistance is in court. This is the resistance of the official groups, of the official bodies, official organs that are acting within the judicial system. So it could be general assemblies of courts, it could be court college, it could be court divisions. For example, we had examples of the all judges of particular court divisions taking some action. And those are different kind of actions. On the one hand, those are kind of general resolutions and calls for action. So, for example, we have kind of wave in Poland after the extraordinary Congress of Judges that was called already in 2016, and around 1,000 judges came to this Congress. So after this Congress undertook couple of interesting statements, there was a wave in Poland of the general assemblies or in given jurisdictions that were kind of repeating the same statements or supporting or developing them further. So kind of general statement, general resolutions, general of those official bodies. So, for example, we also had a second wave of decisions of the General Assemblies was to refuse to opinionate candidates for the judicial positions, because there was an obligation under Polish law that during the competition for the position of the judge, it was required that the General Assembly provides an opinion about the candidates. And since the procedure was seen by judges as unconstitutional, the General Assemblies, for example, refused to take part in those procedures and refused to opinionate the candidates. So, of course, it would stop the procedure as such. However, of course, the reaction of the government was also immediate. They've changed the law, so it was no longer an obligatory element of the procedure. The General Assemblies no longer had to deliver those opinions. But those are also different kind of decisions and actions taken by the court college and court divisions. Some court colleges were defending judges that were target of the hate campaign and mobbing, etc. So again, the government quite quickly changed the law and changed the role of the court colleges and changed the composition of the court colleges as well. So it was kind of legal ping pong or legal jiu-jitsu, if you wish. But those are good examples of those kind of actions. There are also resolutions regarding individual judges, defending individual judges, supporting individual judges, etc., etc. So this is a group resistance in court. And the last category, group resistance out of court, done by different not public institutions or organizations. So here in this category, we have different associations, association of judges, or you said, Jaras, that I should use mutatis mutandi expression, yes, prosecutors, so associations, but also different informal groups created by judges themselves. Like, for example, in Polish case, we have a very interesting group, Forum of Polish Judges, that started as a forum of exchange of information, but then really developed into a very interesting platform. We have different kinds of public statements, open letters, calls to boycott of different groups of judges. We have information, we have awareness raising, we have education, we have international advocacy. This is very interesting because judges traditionally didn't do, the foreign politics before, but due to this crisis, for example, associations of judges have met on a number of occasions actually with different international leaders, and not only ambassadors in Poland, but also leaders in the European Commission, etc. And for this, they were also punished and mobbed for participating in this kind of initiatives. We have the different kind of demonstrations, different kind of public space protests, solidarity campaigns, Or again, in Polish case, in the last 8 years, really hundreds of them. It was kind of incredible movement. And if you go to the website and write a appropriate keyword, you can find numbers and numbers of information about this kind of initiative. And also very important, solidarity with victims. Victims meaning the judges and lawyers being prosecuted, being disciplinary challenged, being targeted as in hate campaigns. Solidarity with them, not just expressed during the solidarity campaigns, but also expressed in a very practical terms. So we created a system of providing legal aid for those lawyers for free, and it's fantastic that Polish advocates and legal advisors undertook this obligation as a pro bono work. But we also organized a system of psychological assistance to the judges. We've been in touch with psychological associations. Because apparently we could talk about it because it's very interesting, but it's kind of sensitive issue. I don't know for what reason, but lawyers are very kind of afraid to use this kind of support, you know, psychological support, psychiatrical support, which is kind of elementary in this kind of situations, and also financial assistance. So there was a system of financial assistance created for those judges who were suspended and part of their salary was cut. This financial system was supporting them in such situations. So as you see, I didn't include here also all the forms that I identified. I identified number of methods of judicial resistance and a number of examples, but those are the most important ones. And based on this analysis of the Polish situation, I wanted to propose something normative. And I wanted to formulate first and then try to answer the question what judges should do in a given circumstances when we are facing the attack on judicial independence, when we are facing attack on the rule of law. And first and foremost, is there a right of the judge to resist? Or is there even something more? Is there obligation of the judge to resist? And honestly speaking, my starting point was, and this was kind of intuitive starting point, that there should be right and obligation of the judge to resist. Because if we come back to the first slides, judges are there to protect me as a citizen, to protect us, our fundamental rights and freedoms, to control other branches of the government. So if there are attacks, if their independence is limited, they are no longer capable of doing this. So, in my opinion, and that was my initial intuition, they should have a right, an obligation to protect themselves, to resist, because this is protection of us all and resisting against the illegal authoritarian methods that tend to not just limit judicial independence, but via judges to limit potentially to limit our rights and freedoms. But the question, of course, being lawyer is you have to kind of operationalize it. And so the question is, do judges have legal, professional, or moral right, obligation, duty to resist? Legal, of course, meaning according to the laws of the country, professional meaning according to the professional standards that are developed in different kind of codes of ethics, set of professional standards, or soft law, international soft law, developed by different organizations. And finally, the moral, that of course depending on the particular morality that we are believing in. So if they have this right, if they have this obligation, how can we justify it with the arguments stemming from law, stemming from professional standards, and stemming from morality? That was my question. And this is now also a question to you. I will leave us, like each of us, like 3 minutes to think about it in a second. So here is the question. The question is whether Polish judges, because that was in the case of Polish judges, have a right to judicial resistance, legal, professional, moral, and whether have obligation to judicial resistance, legal, professional, moral. And I don't know how to do it since I'm here in Oslo and you are somewhere else, but maybe if you have a chance to talk to your neighbor, or those of you who are just watching it solo, let's just think about it for 3 minutes. And for now, we are focusing on judges. We will focus on prosecutors in a second. What is your opinion, the way you know your law, the way you know standards? In your opinion, do judges have right to judicial resistance, legal, professional, moral? Do they have obligation? Think about it, okay? Like, how many? 3 minutes would be enough, probably. Can you hear me?
Yes, we can.
Okay, because if there's no reaction, you don't know the sound effect. I kind of feel strange. So,
But we are
okay, so
muted, you know, just as a whole room. So don't
Okay,
worry,
okay,
we are
okay.
talking, and you can
Yeah.
you can also watch us. So as a big brother,
Okay,
so you can do it.
Okay. So think about it for 3 minutes. Okay, thank you. So during this break, I managed to check the time and realize that it's already 45 minutes that I didn't even know how it went. Anyway, so you have your answers, and here is my answer after the research that I've done, and I will argue why this is my answer in a second. So when it comes to the right to judicial resistance, in my opinion, there is legal, professional, and moral right. When it comes to obligation, there is no legal obligation. However, partially, one can argue that there is something. But when it comes to professional obligation, there is, in my opinion, professional obligation. And when it comes to moral obligation, it of course depends on the moral system. So it might be yes or no. And why I came to this kind of conclusion, of course, this is not the conclusion that everybody agrees with, but why I came to this kind of a conclusion. So when it comes to the legal, the most important element, of course, there are no direct provisions that granted right to resist, of course. However, from existing laws, so here we are talking about hard law and about binding law, both when it comes to the laws and when it comes to the court rulings, we can, in my opinion, interpret the right to judicial resistance, because if we look at the constitutional provisions that, for example, in the Polish case are applied directly, there are provisions related to the rule of law, to the independence. There are provisions detailing the status and obligations of judges. There are provisions outlining judges' rights and freedoms of citizens. So those are indirect resources that can be kind of source of interpreting the right to judicial resistance. When it comes to statutory regulations, we have judges' oath and duties described in statutes. We have number of different adjectives again, or terms, or different terminology that talks about diligence, impartiality, upholding dignity, honesty, impeccable character that is being described by moral integrity, honesty, etc., courage, etc., etc., etc. So the question, of course, is how do we treat, from the legal point of view, judges' oath? But there is, for example, an interesting ruling of the Supreme Court that it's not just symbolic, and there are also writings that those things are not just symbolic. It's not just an oath that you say during the very official ceremony in the presidential palace, that they actually have meaning. We have ratified international agreements as a legal basis. And again, in those from the EU, I have mentioned those that are the most obvious and known by everybody. So Treaty of European Union, underlying the values like human dignity, democracy, rule of law, and obligation of the member states to provide effective legal remedies. We have Charter of Fundamental Rights with its Article 47. We have Treaty of Functioning of the European Union allowing for the preliminary ruling. So those are also kind of indirect provisions that can be used. We have European Court of Human Rights. We have Convention with its Article 6, right to independent impartial tribunal, and those articles that are most often used in case of judges resisting 9, 10, 11, so freedoms of thoughts, expression, assembly, and association. And we have a case law that is really becoming interesting because the court started to use the vocabulary that is interesting in our opinion. In both Baka, Hungarian, and Żurek, Polish case, the tribunal talks about right and duty. In case of Baka, right and duty to express judge's opinion regarding the judicial reform. In Żurek, it is formulated in a way that there is a right and duty to critically assess the reform. But then we have a number of other cases that don't directly say about the right and duty of the judge, but by delivering the ruling, the courts kind of underline that they are right and not their opponents. So, for example, in case of Judge Justition, we have this improper suspension by the illegal disciplinary chamber of the Supreme Court. So there are more cases. However, they don't directly refer to the right or duty of judge to undertake certain positions, to undertake certain activities. Those are rather rulings that defend their rights. And we have a number of rulings of the Court of Justice of the European rulings, but those are not directly, again, they don't directly provide the right or duty to resist, but they rule that what is called by the government judicial reforms are incompatible with the European law. So in a way, it indirectly may support judges resisting these changes and potentially may legitimize judicial resistance. So this is the case when it comes to the right. And from those, of course, this is a kind of short, very summary, but from those provisions, I derive the right of the judge to resist. In case of obligation, there is no obligation. However, again, if judicial resistance counters illegal state action against the judiciary, can one argue, I'm asking, that there isn't a legal duty for judges to reject illicit government directives? This could in some way imply a duty to resist, but there is no such a strong case like in case, or arguments like in case of right. When it comes to professional, it's easier because we have a number of different soft law and I went through numerous documents. I don't have time to talk about them all, but you can see, in brief, you can see how it changes over years, and how it really kind of rapidly changes over the last 20 years. The opinions of CCJE from 2005 are focusing, for example, on judges' judges' freedom of expression, that they can take part in a public debate on judiciary, for example. But when you come to the last opinions, like, for example, CCJA opinion from 2022, in its point 4, it introduces the notion of the judge's legal and ethical duty to defend the rule of law and democracy. So as you see, it goes much, much wider, and it's much, much stronger. And those are quotations in Italy. Judges must be resilient and have a duty to speak out in defense of judicial independence, the constitutional order, democracy, both nationally and internationally when they are threatened. Judges owe loyalty to their nation's rule of law, constitution, democratic institutions, and fundamental rights. While loyalty to the state is vital, it should be secondary. This is very important when democracy and basic freedoms are at risk, compelling judges to defend its position fearlessly. And again, those are not legally binding. This is a soft law. Those are professional standards. But as you see, they really develop. And I have no clue what is the situation when it comes to if there are documents regarding prosecution service. But I think that this clearly shows the possible direction of the development. On the one hand, strategic litigation undertaken by prosecutors in both international tribunals that I have mentioned, but on the other hand, work on developing this kind of standards that even if they don't have legal value, they still have professional value, and they still can be seen as post signs in what direction the particular professional should go. So as you see, it's why my answer to the question whether there's professional right and obligation to resist in this given circumstances, of course, that I provided at the beginning, defined, is yes. And finally, the moral question is that there is right to judicial resistance, but when it comes to obligation, it again depends on the morality. However, in my opinion, as lawyers, we should use international principles on the rule of law and fundamental rights as our moral benchmark. So if we treat this as a moral benchmark, such a duty is, in my opinion, evident. So this is my answer. You can compare it with your answer. If we have time, we'll talk about it. Because now I wanted to ask you the question and stop here. So what about prosecutors? Is there a right obligation of prosecutors to undertake resistance if there is this illegal attack on rule of law, on independence, etc.? What possible methods, actions prosecutors can undertake? Do they have right? Do they have obligation against? You can go through the law that regulates your profession, but also additional question, if you have time tomorrow, you can discuss it in context of the judicial resistance. Additional question for prosecutors is as follows. Should prosecutors prosecute resisting judges if they are asked to or if they are obliged to by the changed statutory law? Or shall they stay silent and impartial, whatever that means, or maybe they should defend resisting judges, referencing it to the legal rules, rule of law standards, etc. So here I have to finish because there is very little time left, so I stop here, and the rest of the presentation is not that important, just a couple of photos. This is Justice Defense Committee, and it's extraordinary body, and I think it's presidential in the world's experience, because It is combining the prosecutors organization, judges organizations, and number of civil society organizations. This is a congress of judges with barristers and legal advisors, unfortunately not with prosecution office, but it was of course impossible. This shows the so-called legal complex. So all the lawyers united to defend liberal values. This is example of international support, a march of 1,000 goals, where people from over 20 European countries came to Poland and provided their support. This is the protest that prosecutors also privately took part in front of the Supreme Court, etc., etc. So let's stay with this question, and Jaras, the floor is yours. Thank you very much for your attention.
Łukasz, thank you very much. Again, I hope you deserved an applause. Especially for making the half an hour lasting 1 hour. And
you should let me know.
Yeah, no, I was writing to you, but if you start, talking, that no one can stop you. I know it. Okay, so I think you left us with a brilliant homework, or just night work, I don't know, or maybe the work for tomorrow after breakfast, and just time for discussing also during our round table that we will conclude the whole seminar with. So, Łukasz, again.
If anybody, if like one or two persons
have, if there are some comments,
reaction, especially critical, that would
especially
be great,
critical, only with timing, that's the only critical, but it can be. Okay, so are there any questions, comments, interventions?
I'm sorry, guys. I was.
Unfortunately, no.
Okay.
So, Łukasz, again, thank you very much. It was absolutely amazing presentation, and also
Jaras, please listen. Please talk to people, because
I will.
The lack of reaction might mean that they are simply shocked and they think that this crazy guy from Oslo is talking some crazy
probably you are right. Okay, probably you are right. So now we are having 45 minutes before the dinner, and there was also one thing that Joanna wanted to say, but Łukasz, thank you very much.
Thank you very much. Bye.